Hello, friends. I welcome you all to this session of Indian Evidence Act. And we were seeing the privileged communication which is between attorney and the client. And in it, we have seen that there are section 126 to section 129 deals with it, and in section 126 we have already seen that whatever communication, whatever document, or whatever advice that has been shared between client and the advocate is privileged as such. So no barrister, attorney, pleader, or vakil will be permitted, or this advocate will not be permitted to disclose any communication, any document, or any advice that has transacted between the client and the advocate. Now, section 127 is a corollary to it. What it says is that this privileged communication, or this privilege, also attach or it applies to the interpreters and the clerk or the servant of this barrister, pleader, attorney, and vakil. So not only the pleader, not only the advocate is barred from disclosing it, but also persons who are working in his office, who might come to get hold of or know of this communication, will also um, be in a position to disclose it. Or the advocate may not himself do it, rather ask his servant, clerk, or interpreters to do it. So this section 127, it says that even these clerks, servants, or interpreters who are working within these attorneys or vakil's office, they are also prohibited from disclosing it. Now, next is section 128. This is very important as it lays down that what will happen if the client himself volunteers to give evidence. So, is the privilege at that time when the client himself volunteers to give the evidence of the communication which has taken place between him and the advocate? Can in that case advocate speak out what communication, document, or advice was shared between him or and the client? So, section 128 says that even if this client volunteers to give the evidence of this communication, yet the advocate cannot. Yet, for the as far as the advocate is concerned, these uh, communications are as such privileged. So, section 128 provides that privilege granted under section 126 is not waived by the fact that the party who made the communication himself appears as a witness and gives evidence at his own instance of the matters which are covered under section 126. So, if the party himself comes and gives the evidence, yet the privilege stands even when such party calls the lawyer as a witness. So even if the client calls the advocate as a witness, yet the privilege stands. However, the privilege will be waived if he questions the lawyer on the very matter of the communication, as his questioning will be deemed as his consent to disclose, and that lawyer will be permitted to disclose. Now, one exception has been said that suppose the client calls the advocate, at this stage the privilege stands. But if the client questions him on the very matter as to what was the communication, what was the document content, or what was the advice which was shared between both of them, then in that case it will be presumed that client has given his consent, and then the privilege no longer stands and advocate can give the evidence. So section 128 makes privileged uh, the communication between client and advocate privilege even if the party volunteers to give the evidence himself. The only exception is when the advocate is called as a witness and he is asked a question regarding that particular communication itself. Now, section 129 is also important, and what section 129 says is that, see, section 126, section 127, section 128, they stand on one footing, while section 129 stands on another footing. What it says is that the communication between advocate and the client is privileged communication. But section 126 bars the advocate to disclose it. Section 127 bars the servant or the interpreters or the clerk of the advocate. Section 128 says that even if the client has volunteered to give evidence, yet they are barred. So he had till section 126 to 128, we are seeing that the advocate is barred and his employees are also barred. But section 129 gives privilege to the client, that no one will ask the client as to what the communication or what the document or what the advice was shared between him and the advocate. So section 129 provides that no one shall be compelled, so no client will be compelled to disclose to the court any confidential communication which has taken place between him and his legal advisor. So what communication has been taken place between the client and the legal advisor, the client will not be compelled to disclose it. So however, when the client offers himself as a witness, and that case he may be compelled to disclose such communication as may appear to the court necessary to know the truth or explain the evidence which he is given. So when the client himself offers as a witness, then in that case he may be asked if necessary. So, what section 126 is, that section 126 prohibits lawyers from disclosing which matters which has come to his knowledge from the client for professional purpose. While section 129 gives protection to the client, as we have seen that 126 gives protection to the lawyer, while 129 gives protection to the client from compulsion to disclose any confidential communication between him and his lawyer. So that is what is section 129. And as we have seen at the very beginning, that the communication between the client and attorney is privileged in section 126 to 129 in one, and we have seen it that pleader's servant very attractive, we can remember it that way, that 126 says that professional communication, what the advocate cannot disclose whatever has client has told him, then servants also cannot disclose. Then even if the client volunteers to give evidence of the fact, yet it is privileged. And then that section 129 says that the client cannot be compelled to disclose the communication as well. So that's all for today. Thank you, friends.